Default text. This case looks simple on paper. A probation violation, a technical mistake, and a defendant who's already completed most of what the court asked of him. But don't let that fool you, because in this courtroom, technical violations still matter, and judges don't take kindly to people who decide which rules apply to them. John Closa was placed on deferred adjudication for assault of a pregnant person, a serious charge. And instead of prison, he was given something far more valuable: time. Time to prove he could follow the court's rules. 2 years in, with 3 years left, he leaves the county without permission. No emergency, no court approval. Just a decision he made on his own. And here's the tension. Probation is a contract. Not with the prosecutor, not with defense counsel, but with the court itself. So when the judge asks a simple question, why are you leaving the county without permission? It becomes clear this hearing is no longer about paperwork. It's about accountability, judgment, and whether the court should keep believing in someone who already got a second chance.
Well, he has completed many of the things that he had to complete, and he's only 2 years in, so he has 3 more years to go on his probation.
Why is he leaving the county without permission?
It was 25 minutes from his home. I mean, technically it still is out of the county, but it's 25 minutes from his home for a family function with his family.
Let's roll, nerds.
John Closa? Good morning. How are you doing?
Well, Your Honor, thank you.
It's good seeing you.
Always amazing seeing you.
Oh, thank you so much. I hope everything is okay with, well, I don't want to say okay, but I hope everyone is doing the best they can.
Yes, we are.
Okay. All right. I'm going to call 2021 CR 5795, State of Texas versus John Leal Closa. Can I have parties announced for the record for the state?
Travis Banks of the state of Texas.
Defense?
Adeli Silver for the defense.
Are you John Leal Closa?
Yes, ma'am, I am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney?
Yes,
Did you understand it?
Yes, I did, ma'am.
Are you the same John Leal Closa who was placed on deferred adjudication in 2021 CR 5795 for the offense of assault of a pregnant person on August 31st, 2021 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 7, on or about the 30th day of April 2023 in Wilson County, Texas. The defendant, John Leal Closa, departed Bexar County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
True, ma'am. The state will waive and abandon the other allegations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 7, the court could find it true, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 7?
Yes.
Court will find violation of condition number 7 true. Is there an agreement?
Yes, Your Honor. The agreement, should the court follow it, is to deny the motion and to alter and amend the conditions to add hostility and aggression management course and the family violence impact panel. And those, with those additional conditions, that is the.
All right. Why are we needing hostility management and anger course and family violence impact panel when he was supposed to be doing the BIPP course?
He has finished the BIPP course. It was finished last year. Yes, and then there's a new allegation of a new number 1 in Wilson County. It is still pending.
So why should I continue him on probation? I don't understand. He leaves the county without permission. I'm not even going to consider the fact that there is a pending case in Wilson County because you all didn't go on that. But I do have the state and you all agreeing to hostility management course and the Family Violence Impact Panel live. So I'm trying to figure out, why shouldn't I not just send him to prison?
Well, he has completed many of the things that he had to complete, and he's only 2 years in, so he has 3 more years to go on his probation.
Why is he leaving the county without permission?
It was 25 minutes from his home. I mean, technically it still is out of the county, but it's 24 hours, 25 minutes from his.
This is where the legal nuance really matters. The defense argues that the trip was short, only about 25 minutes from home and tied to a family function. But probation doesn't operate on distance or convenience. It operates on permission. Leaving the county without approval is a clear violation, no matter how minor it may feel to the person on supervision. And the judge makes that crystal clear. What's especially important here is that the court explicitly chooses not to consider a pending new case, showing restraint and focuses solely on what's proven and admitted. The judge isn't angry because he traveled. She's concerned because he decided for himself when rules mattered. And that raises a question for everyone watching. If prohibition is meant to test whether someone can follow rules consistently, does a small violation still show a big problem?
Home for a family function with this family.
State?
You're right. I think in the hostility and aggression management course, they do teach some different skills than you learn in the matters intervention course. And I think that maybe with these new skills, they could serve the defendant well, and that he could complete the rest of his probation successfully.
All right. This is what the court will do. Is there anything you wish to say, sir?
Ma'am, I apologize for my actions, and I won't mess up again. If you please can give me this opportunity to prove to you that I can do better, I will, ma'am.
All right, this is what the court will do. Court will deny the motion, alternate amend conditions to include hostility management course, family violence impact course live panel, and 10 days in the Bexar County Jail as a condition. All right, so you're going to go into custody today, serve your 10 days in the Bexar County Jail. And what you need to remember is you have to follow the rules of the court. Do you understand?
Yeah.
All right, so immediately upon your release, you need to get in touch with your probation officer, and you need to remember you're not allowed to leave the county. You understand?
Yes, ma'am, I do.
And you need to remember you will go to prison, do your time, come out, and then you're going to be right back here. And who knows, I may have won the lottery, enjoying my best life on a beach. The parties that you see here may not be here. You may end up with different people, and there may be a different outcome. You understand? That the rules of this court are the rules of this court, because this contract is not between your attorney and the state. This contract is with the court. Do you understand?
Yes, ma'am.
All right, good luck to you.
I had no choice. I've been reading feedback.
Stop talking. Stop talking.
Miss
Stop talking.
Holly.
Feedback when I take custody of a child.
Miss
Stop
Holly,
talking. Stop
please stop
talking. Miss Holly, stop talking. Absolutely nothing you say is going to help you right now. Miss Patton?
Your Honor, based upon that, my original, I would object. I think it still stands. She hadn't even stayed with the conditions as are right now. She's in the home with her. And how can the child and the victim in question be safe enough to tell me what's really going on if she's in the house with her?
And Miss Rhonda, this is not me doubting you. I can feel my blood pressure going up. Wait a minute.
I agree, Your Honor.
Miss Holly, I am sorry for your condition. However, I am not sorry that you couldn't follow instructions. I mean, and the nerve to show, it's like, what in the world? You didn't even try to hide it.
To you and lied to you.
No,
Miss Holly.
absolutely nothing you can say. Miss
Try to have
Rhonda
a
does not want you to
Miss
say
Holly.
a word. It is not going to help you. So, Miss Rhonda, I'll tell you what, you can place this back on another time. I'll give you a chance to have a conversation with Miss Holly.
In the end, the court strikes a balance between accountability and restraint. The judge denies the state's motion to revoke probation, but she doesn't ignore the violation. Instead, she tightens the conditions, adding anger and hostility management, a family violence impact panel, and 10 days in county jail. It's a clear warning shot. Probation is not automatic, and patience is not unlimited. This case reminds us that deferred adjudication is a privilege, one that can disappear quickly if the court loses confidence. Now we want to hear from you. Was this punishment fair for a first technical violation, or should the judge have been stricter? If you found this courtroom moment as revealing as we did, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom breakdowns where every decision has consequences.